Well, welcome. Hopefully everyone had a good lunch. I know there's nothing that gets me going like DOL, so hopefully you feel the same. Again, my name is William Nelson. I'm one of the Associate General Counsels here at IAA. I've met some of you. Hopefully I'll meet more of you throughout the day. I have some distinguished and esteemed panelists today, and since I can't do it justice, I will let them introduce themselves.
Thank you, William. I'm Mary Ann Pizzari. I'm an attorney with Picard, DeGinnis & Pizzari, which is a law firm in town.
Aaliyah Robinson. I'm currently with T. Rowe Price in their Legislative and Regulatory Affairs Department. I've been there about 4 months, and I say that because a lot of what I say still comes from my previous work with ERIC, the ERISA Industry Committee, and with the Chamber of Commerce lobbying on their behalf. So just to keep that in mind.
Hi, everybody. I'm Jenny Eller. I'm a principal at Groom Law Group, a ERISA-focused law firm here in D.C.
Okay, great. Thank you. And just, to start the session for housekeeping, the CE word is element. Element. So the code word is element. So let's get started. We do have a packed agenda today. Again, thank you for coming to this panel. It definitely has been a busy 12 months at the DOL. I guess, you could basically say that any year. But I feel like this past year has definitely, been pretty intense. We're going to cover several rulemakings today. The DOL ESG rule, also the proxy rule, and I'm sure a lot of you are, dealing with the fiduciary exemption right now. And also, if we get to it, some future actions and also questions. Since this is a little bit of a smaller room, I'm not going to do the note card. So if you have any questions, I know there's a little bit of light here, but if you could just try to raise your hand, get my attention, we'll try to answer those. But if not, feel free to come up afterwards. I can definitely collect any questions and submit them to the panel afterwards. So don't feel like you can't ask questions. So. Okay, so starting off on the DOL ESG rule, Mary Ann, why don't you get started?
Okay, thank you, William. Well, let's start first of all with the fiduciary duties that lie at the heart of the ESG and the proxy rule, and those are the fiduciary duties of prudence and loyalty. And the fiduciary duty of prudence is that the fiduciary has to act with the care, skill, and prudence that a prudent person would use in a like situation. It's pretty much like the duty of care under the Advisors Act. With regard to the duty of loyalty, which again, there's a duty of loyalty under the Advisors Act, you have to act, or the fiduciary has to act solely in the interest of plan participants and beneficiaries, and for the exclusive purpose of providing benefits to the participants and defraying expenses of plan administration. So that's the underlying. So when we talk about the ESG rule, and I guess what this whole thing, the reason that this is somewhat uncertain for the industry, for the fiduciaries, the folks in the room, is that both ESG and proxy have been subject to some political hokey-pokey, regulatory hokey-pokey. Over the years, the Republican administrations have taken one view, the Democratic administrations have taken another view. In 2020, there were rules both in the ESG and proxy front, and I think it's fair to say that the rules were rather hostile both to ESG investing and proxy voting. In 2021, with the change of administration, there was a change in philosophy. The 2020 amendments have been, the effectiveness has been stayed or the enforcement has been stayed, and the DOL came out with a proposal last year to rescind parts of the rule they had just adopted. So what we're going to try to do here without confusing everybody is give you the basis of what was done in 2020 and what has been proposed to be done for 2021. That proposal is still outstanding. The materials in your course book include some compliance tips, which I hope will serve you well regardless of how the political winds shift, and give you some footing that you can use in your own shops to deal with these issues. So in 2020, what the DOL did is they amended the investment duties rule. And if you look at the amendment, you will not see the words ESG anywhere. They had proposed an anti-ESG rule. In response to the comments, they removed any reference to ESG from the rule, but the preamble makes it clear that that's what they're talking about. The preamble to the rule says that there are heightened concerns under ERISA with ESG investing, and the way this plays out in the actual language of the rule is that that the fiduciary is required to consider solely pecuniary factors in selecting an investment. And a pecuniary factor is a factor prudently determined to be expected to have a material effect on the risk return of the investment based upon appropriate investment horizons. The 2020 amendment also said that your risk return analysis has to include an analysis of reasonably available alternative investments. The rule goes on to say that the fiduciary cannot subordinate the interests of the plan participants and beneficiaries in their retirement income or other financial benefits under the plan to other objectives, and they cannot sacrifice return or assume additional risk to promote non-pecuniary goals. So that's the basics. They do go on to say that, that non-pecuniary factors, i.e. ESG, can be used as tiebreakers if you have two investments that you cannot distinguish on a pecuniary factors alone. But in order to avail yourself of this tiebreaker opportunity, they require extensive documentation. You have to document why fiduciary factors alone will not be distinguished, how selected alternatives compare to other alternatives with regard to portfolio diversity, return, and liquidity, and how non-pecuniary factors are consistent with the participants' and beneficiaries' interests. So again, what they did is they say you can use it as a tiebreaker, but they made it difficult to do. Moving on. They also, in the 2020 amendments, addressed participant-directed individual account plans, and there was good news and bad news for ESG there. The DOL said that a fiduciary can select a fund, product, or model portfolio as a designated investment alternative, even if that fund, product, or model portfolio promotes or supports a non-pecuniary goal, assuming all the other analysis is accurate. But the kicker is the 2020 amendment said that that type of investment cannot be selected as a qualified default investment alternative. So in other words, you can't select that as the default for the plan participants. So that's what happened in 2020. And as I said, the new administration came in, new view on ESG, and what they have proposed to do is to eliminate this focus on solely pecuniary factors. But before you get too excited, the fundamentals of ERISA are still there. You still have to act in the best interest of the plan participants with an idea of maximizing their ability to have retirement income or other financial benefits under the plan. It continues to be the case that you can't subordinate those interests to non-pecuniary interests, that you cannot assume greater risk or accept lesser return in order to support or further some other goal. The other thing they have proposed to do is to change the tiebreaker standard from that indistinguishability. You can use a tiebreaker if it's indistinguishable and if you have a lot of documentation. And what they're going to do is they're going to move to, if you can use non-pecuniary factors as tiebreakers, if all things being equal, two alternatives are equally good for the plan. So they're loosening up the tiebreaker standard. And again, they're dropping the extra documentation that's required. And then another thing they're doing is they're reversing the prohibition on using ESG funds as QDIAs. But the kicker there is if you want to use an ESG fund as a QDIA, you have to make a disclosure, full and fair disclosure to the plan participants of what collateral benefits you have considered. And I know there are some, that piece of the proposal generated quite a bit of dissent, I think, because I think from a practical standpoint, that's going to be difficult. Now, the other thing, and this is where we really get ESG heavy, is that the proposal does talk about ESG and particularly climate change, and actually swings the pendulum quite far, because it says not only may you consider ESG factors and climate change, but that when, for example, you're looking at projected long-term returns, you may often have to look at environmental and climate change matters. And again, that has been the focus of some of the commenters who said, look, we're fiduciaries, give us some credit for knowing when something is material and has an economic, is an economic consideration. And people don't want to be told they have to look at ESG any more than they want to be told that they can't look at it. The proposal also says that, again, they've moved away from everything has to be solely pecuniary, and the DOL says the fiduciary can look at anything that is basically relevant, but then they list a laundry list of environmental, corporate governance, workforce, and the types of issues that they think fiduciaries may want to look at. So overall, the thrust of this is to go from a rule that was hostile to ESG to a rule that is very welcoming, encouraging, and one might say impelling ESG.
Yeah, absolutely. And thank you, Marianne. Just some questions, Aaliyah, from your perspective. As Marianne stated, the fundamentals are still the same. They did come out with this proposed rule. Do you think that'll give firms more comfort to develop more ESG in the ERISA space, or they're going to still kind of hold their powder?
I think it does. I think especially that stepping away from the prohibition of ESG and QDIA funds was a huge step in allowing employers and plans to really look at those again and include those. In addition to the DOL kind of going back and forth, the other piece of this, especially for a company like T. Rowe Price that deals internationally or globally with this, is that you have pressure from particularly the EU and the UK to actually include ESG in a lot of investments. And so dealing with that tension before was tough, but now that the DOL has moved a little bit more in this way, obviously those two factors, I think, help to make ESG something that we will see more of in the plan space.
Got it. Yeah, and that makes complete sense. Jenny, I have one for you. So there's been a recent RFI that the DOL put out talking about climate-based financial risk. Do you think that's going to have any impact on the final rule, or?
It didn't. The RFI came out and essentially said, well, on October 14th, we issued a proposed rule, and on October 15th, the president issued an executive order on climate change, and so here we are with our RFI. And it's not clear whether there was some miscommunication or if the department is really looking at these things as very separate. And then if you read the RFI, it really talks a lot about whether the department should require plan sponsors to report certain things about investments for purposes of understanding how plans are investing related to climate change in particular. So I don't think it's going to have much of an impact on the rule itself, but I do think we should expect that perhaps if there's another Democratic administration after this one, there'll be plenty of time to issue a new Form 5500 rule that will probably require a lot more in the way of reporting.
Absolutely. Yeah, and I definitely think this is an area to keep an eye on because the SEC, obviously, it seems like every day we hear a report about, an upcoming ESG rulemaking, so how those kind of interact with each other. So, DOL proxy rule, Marianne, take it away.
Okay. We're still in the investment duties rule, and they did these two rulemakings, they being the DOL. They did the rulemakings in 2020 in two phases. So they led off with the ESG phase, and then it was a 1-2 punch, and then they came in with the proxy. And it was pretty much the same process. They came in with an incredibly draconian proposal that would have required fiduciaries to do a cost-benefit analysis every single time they wanted to vote. And there were all kinds of tripwires for compliance officers. In response to the public comment, and this again, both of these rulemakings were very rushed. In response to public comment, the final proxy rule that came out at the end of 2020 was much lighter and less draconian, but still infused with the notion that there was something not quite right about proxy voting. So what the proposal from 2020, it started out fine. It started stating fiduciary principles. And the first one, which comes from the Avon letter in 1988, is that a proxy vote is a plan asset, and a proxy vote has to be managed with the same care and skill that the shares to which the proxy vote pertains are managed. So that's no surprise there. Fiduciary duties of prudence and loyalty apply to proxy voting, no surprise there. It also imposed specific requirements in addition to just stating. If they had just stated the fiduciary principles, I think it would have been fine, but they went on and they imposed specific requirements. And again, it was in lockstep with the ESG rules. So when proxy voting, the fiduciary has to act solely in the economic interest of plan participants and beneficiaries, cannot promote non-pecuniary benefits unrelated to financial interests. The fiduciary has to consider costs, even though they did not go ahead and impose a cost-benefit analysis on a vote-by-vote basis. The fiduciary has to evaluate the material facts underlying a vote, and that's similar to what's required under the Advisors Act, under the fiduciary duty. They imposed a special record-keeping rule for fiduciaries who vote, and they had 3 versions of requirements for monitoring proxy advisors, the use of proxy advisors, because if there's one thing the DOL disliked more than proxy voting, it was proxy advisors. So 3 versions of that. And then they had some safe harbors. There was a statement in the 2020 rule to the effect that fiduciary duty does not require a fiduciary to vote every single time. And again, that's not controversial. That's always been the case. But the rule also had some safe harbors that fiduciaries might consider to limit the voting that they do. And one safe harbor would be to have a policy and procedure where voting was done only where the issue was expected to have a material economic effect. And in the proposing release for that, they cited some ICI statistic that might reduce voting by 94%. So they were really, that was a pretty big hammer. The other safe harbor would be that a fiduciary could vote only if the percentage of ownership relative to the plan's securities investments was above a threshold where you could say this was a material issue. And of course, the problem with that is something could be a low percentage but a very high dollar value. And the other problem with that is very hard to figure out when the plan's assets are allocated among different fiduciaries and funds. So you don't know what percentage that is. But that was the 2020 rule. Again, they also had something on pooled investment vehicles, that if you have different ERISA funds, that the fiduciary to the manager of the pooled investment vehicle must take all of those funds' guidelines into account, or the fund can require, as a condition to investing in the fund, that the plans adopt the fund's proxy guidelines. So same thing, that has been, the enforcement of that 2020 rule has been stayed. And as part of the same ESG 2021 rulemaking, DOL has proposed to pull back some of the provisions that they had just adopted. One thing is they eliminated the safe harbors. They also proposed to eliminate the safe harbors. They also proposed to eliminate the statement that you don't have to vote every ballot issue. But in doing that, the preamble makes it clear that they're not making a substantive change, that in fact that's the case, but that they think that the combination of that statement and the safe harbors, it will encourage fiduciaries to be indifferent to proxy voting, and they don't want indifference to proxy voting. I think what they said was abstaining from a vote is not a neutral act, so they're planning to eliminate that. They're also proposing to eliminate the record-keeping requirement. Again, not that you don't have a requirement to keep records, but that is already incorporated in the duty of prudence. And of course, in 2042, under the Advisors Act, there's a whole host of proxy voting record-keeping requirements. So again, it was the idea that hitting fiduciaries over the head with things they were already required to do gives a bad impression that the DOL doesn't like proxy voting. And for the same reason, they have proposed to pull back the duplicative requirements to oversee proxy advisors. And of course, you have to do that. You have to do it under the Advisors Act. Like any other service provider, if you are hiring someone, you have to do due diligence, you have to do monitoring, and you can't offload your fiduciary duty by hiring somebody else to vote proxies for you. So again, as with the ESG, in the course materials, there are some, what I hope you would find to be practical compliance tips that are designed to work with whatever happens with the DOL and whatever happens with the rulemaking. And I will stop there.
Thanks, Mary Ann. So yeah, we have these two proposed rules, ESG, proxy, but fiduciary exemption. I'm sure everyone's in the thick of it. I know I've gotten a lot of member questions about it. Again, please feel free to reach out. Always happy to answer them. We do have a DOL committee. Put in a plug. I do serve on that committee. So please feel free. But so let's get started. Jenny, you want to take it away?
Sure. Let's see. So Mary Ann did a good job of laying out what the duties are that ERISA imposes on fiduciaries. You can be a fiduciary under ERISA if you manage plan assets with discretion. We'll put that to the side for the moment because that's not really the subject of this exemption or this discussion. You can be a fiduciary if you have authority over the administration of plans. Also, not one of the things that is important for this conversation, but you can become a fiduciary if you provide investment advice for a fee. And once you are a fiduciary, not only to an ERISA plan, not only do you have the substantive duties that Mary Ann laid out, you also have the responsibility not to cause the plan or an IRA to engage in a prohibited transaction. And if you use your fiduciary authority to cause yourself or an affiliate or someone you have an interest in to receive an additional fee, then you have caused a prohibited transaction and breached your duties to act solely in the interest of the plan or the IRA. So the purpose of the exemption is to address situations where you have people who are investment advice fiduciaries who are giving advice that would cause them to receive a fee and therefore be prohibited unless there is an exemption that covers that arrangement, and that's the exemption we're going to talk about. So first thing everybody should know is that it's March 3rd, 2022, and the DOL's non-enforcement policy, which they had in place for quite a long time, ended on February 1st, so we're more than a month into a situation where you, if you are an investment advice fiduciary, and you are providing advice that could cause you to receive an additional fee, say rollover advice, for instance, you need to have an approach that's different than the DOL non-enforcement policy. It may be that you need to comply with this exemption or a different exemption, or you may need to think about whether you're really a fiduciary in providing investment advice, and that's kind of the key for what we'll talk about here. Do want to mention that in 2016, many of you probably know, the Department of Labor issued a new interpretation of the statutory definition of an investment advice fiduciary. That interpretation was ultimately struck down by the Fifth Circuit, and so the department sort of went back to the drawing board, and most recently in 2020, they proposed this exemption, PTE 2020-02, and essentially said, well, we're not changing the regulatory definition of what it means to be an investment advice fiduciary. And that definition is what we call the five-part test. So if, for a fee, you make a recommendation about securities or other property, you do that on a regular basis. There's a mutual understanding between you and the person you recommend the securities to that your recommendation will serve as a primary basis for their investment decision, and that your recommendation will be individualized to the needs of the plan. If those things are true, you are an investment advice fiduciary. And in the preamble to this exemption, the department sort of said, well, we're still operating under the old five-part test. We've had regulations in place for 40 years, but we have a new interpretation of the elements of that test. So for the last many years, people have thought, well, you have to give advice on a regular basis. So if I give a one-time recommendation, that's not a regular basis. I'm not an investment advice fiduciary. And the department said, well, you kind of don't get one free bite at the apple. If you make a recommendation and then subsequently you make more recommendations, you sort of look back to that first recommendation, and that's the beginning of your regular basis relationship. And that's not how most people have understood that rule for many years. The department also said, look, this mutual understanding thing, you can't eliminate that prong of the test by simply having some fine print that says, mutual understanding means we both understand that my recommendation is going to serve as a primary basis for your decision. This is a sales conversation, and therefore, I don't have a mutual understanding that that's how you're going to use my information or my recommendation. And the department said, you can't just sort of small print away the mutual understanding. We would look at it and say, would a reasonable person believe that the two folks or that the recipient of the advice had a reasonable expectation that there was that kind of understanding. So they really kind of broadened their interpretation of the existing test, and at the same time, they revoked a 2005 advisory opinion in which the question had been, well, if I talk to a plan participant about their distribution options, and I make a recommendation that they roll out of the plan, will I have a problem? Will I commit a prohibited transaction if their decision to roll out of the plan earns me money? And in that 2005 advisory opinion, The department said, no, that's not advice. Unless you have a pre-existing fiduciary relationship with a plan, that sort of conversation is permissible, doesn't make you an investment advice fiduciary, and therefore you don't need an exemption. And for years, people relied on that letter to say that when I'm providing recommendations for people to roll out of an ERISA plan into my IRA product, I'm not a fiduciary, and therefore I don't need an exemption. And in the preamble to 2020-02, the department said, we no longer believe that that analysis is correct. We now think that if you meet the 5-part test, read our new expanded version of the 5-part test, when you're having a rollover discussion with someone, then you are a fiduciary, and if you are able to receive compensation as a result of that recommendation, you would need an exemption, and in fact, we have one for you. So that's the kind of background behind this exemption. And then we can, move forward to the exclusions.
I think
There you
for, just, I guess there's kind of two situations. Say, I definitely want to rely on the exemption, but I can't because I'm excluded, or I can rely on the exemption, but I just don't want to. So if you could kind of talk about those two situations.
Sure. So the exclusions are pretty important. As I talked about, if you provide discretionary asset management, you're an ERISA over ERISA assets or IRA assets, you're an ERISA fiduciary. This exemption, and you can have your own conflicts, right? You can make a recommendation or you can make a decision as a discretionary fiduciary to cause the plan to make an investment that causes you or your affiliate to receive an additional fee. Invest in your own mutual fund or CIT or separately managed account, that sort of thing. You can make asset allocation decisions that will result in compensation changes. Any of those things, you're a fiduciary, you're making a discretionary decision, you might have a fee conflict, you need to find some other exemption, because this exemption is only available for investment advice recommendations. The one caveat I have to that for discretionary asset managers out there is, if you are under normal circumstances operating as a discretionary manager and you come upon some fee conflict for which you don't have an exemption, like you want to move client assets into your own separately managed account. Right now, I don't have an exemption for you. There isn't a way to do that. You have to give up your discretionary control, maybe have the client direct you, maybe you just can't do it, maybe you can't collect a fee. The way this exemption reads, it doesn't apply in instances when the financial professional and financial institution are acting as a discretionary fiduciary. You could say to your client, I'm conflicted and I don't have an exemption. I can't make this decision for you. But I can rely on this exemption to make a recommendation as to what you should do, as long as you meet the conditions of the exemption, which you may or may not want to do. But you can probably sort of switch lanes and become an advice fiduciary and rely on this exemption if you wanted to. But just for your regular discretionary management business, 2020-02 is not helpful. Another big one is it's not available to the in-house plans of financial institutions. For many financial institutions, their own employees' retirement plan, 401k plan, is a pretty decent rollover source. People who work at the company, they trust their colleagues, and when they're ready to leave the plan, they might want to roll over into the financial institution's IRA, say. They can do that, but they have to do it themselves. The financial institution or financial professionals, you can't solicit, or at least you can't be an advice fiduciary in doing so. And that's a huge hurdle, and the department has received a lot of comments about that and a lot of pushback. And then the last one is robo-advice. For some reason that I still don't understand, the department decided to exclude robo-advice, which in all other instances it has said, advice is advice, regardless of where it comes from. And so they point to the PPA exemption, which has a investment advice exemption for digital advice, but it's pretty hard to get along with. So they've gotten a lot of pushback on this too.
Yes, what about some options? Say, I want to give advice in this area, but I don't want to rely on the PT 2002.
Right.
You know, a lot of what I've heard is, you know, kind of the two main options are either the unsolicited or kind of the investment education route. So I don't know if you could just talk about those.
Right. So unsolicited rollovers, that we hear a lot about that. So some firms are saying, look, I especially when it comes to rollovers, where the department would say, well, if I advise a participant in an ERISA plan to do a rollover, I'm really kind of giving two pieces of advice. Piece one is you should sell everything in your ERISA plan. That's a recommendation, right? If you're going to roll over, you have to sort of liquidate everything and move out. Maybe not company stock in some cases, but nonetheless. So that's one recommendation. The second recommendation the department would say is then once that decision, that rollover or exit from the plan has happened, where am I going to put my money? Which type of IRA, which provider, that sort of thing. And so some folks are saying, I don't really want to be an ERISA plan fiduciary. If I give somebody a recommendation as to what they should do in their ERISA plan, I don't like that because ERISA has participants and beneficiaries can sue for breach of fiduciary duty. It's got a lot of ugliness to it. So maybe I'll just say to people, look, I'm not willing to advise you about whether or not you should stay in your plan. You have the choice to stay in your plan, leave your plan, you pick. Once you have decided, if you decide you want to roll over, then come and talk to me. And then I will talk to you about where you might go now that you've decided to have a rollover. Or they might say, I can't do either of those things. So you need to make your decision, and if you want to essentially walk into my office with a check, I will be happy to then, provide you, say, discretionary management of your IRA or something like that. So that's really what unsolicited is, and it's great because you don't have to comply with the exemption. It's not particularly customer friendly for people who want some help in deciding what to do. But there's not a lot else you can do. People say, well, can I say, if you decided to roll over, here's the type of thing I would probably recommend to you. The department would say, that's a recommendation. So there's not a lot of room there, but I know a lot of firms are kind of really trying to push the boundaries of what that might be. There is a sort of a hire me exception, and the example in the preamble to the exemption sort of says, well, if you might say to someone, I've worked with Joe for 15 years, and I think we have a good relationship, I'd love to talk to you about the kinds of, about my abilities as a manager. That wouldn't necessarily be a recommendation, but the next steps of, and here's why I'm a great manager, and here's the types of things that I might cause you to go to invest in, that's probably outside of the hire me context. And then finally, people are looking to other prohibited transaction exemptions, primarily PT 8424, which has many fewer conditions. It's essentially disclosure-based. It's a much older exemption. And truth be told, I think the department, they're very aware of that exemption. They view it as creating an unlevel playing field, notwithstanding the fact that they actually created the unlevel playing field by putting out 2020-02. But so I think, we very much expect that exemption is going to be either pulled completely or it's going to be reissued in a way that will make the substantive conditions virtually identical to 2020-02.
Okay, great. So, I think at this point here, say, look, we have decided we're going to rely on PTE 2020-02, kind of the different conditions, the different disclosures. Since we have about 10 minutes left, I thought we could just kind of all engage in discussion about what are some of the challenges you see with that and pitfalls for RIAs. And again, please feel free to ask questions if you see something like, oh man, these policies and procedures, where do I put my fiduciary disclosure? What disclosures do I have to make? Thankfully, the more onerous rollover disclosures aren't until the end of June, I believe. So, we definitely won't get into those too much today. Don't worry, we will have a webinar on that they don't know this yet, but I'll probably rely on these folks to help me out. But so yeah, if you could just kind of talk, from each of your own experiences, Leah from, the in-house experience, Jenny, Marianne from the law firm experience, kind of what are some of the challenges you see of, say, hey, I've decided to rely on this PTE, kind of, where do I go from here?
So I'll start because we've actually decided not to rely on it.
Okay.
But that still is a process. You don't just kind of wake up and say, okay, I'm not going to rely on it and move on. We had to look at, we have obviously an institutional business and a retail business, how those two were interacting with each other, what conversations they were having with each other. We provide discretionary advice, so we weren't going to use it generally, but we're looking at whether there were other ways to look into it, and looking at some of these disclosures and what that would mean. And so we've decided not to use it at this point, but that's an ongoing conversation. And even though we're not using the PTE, we did have to review and have been reviewing, again, our conversations. So we have, documents for our retail side in terms of whether if someone calls, but they are an institutional client, and thinking about a rollover, what our people can say to them in terms of, education, because we don't want it to be a recommendation. And the same thing on the institutional side, if someone calls and says, I've just left or I'm about to leave my employer, what should I do? There is a script now that didn't used to exist in the same prescriptive form that it does now. So even if you don't use the PTE, there is still a lot of process and changes that at least we had to go through, and I think other companies as well.
Well, one thing that I found, and it's not the first issue I found it in, but the compliance officer will say, oh, no, we're not using this, we're not doing this, and I'll come up with disclosure. Now that it's ADV season, we're putting things in ADVs. And then I'll say, well, so your portfolio managers are good with that and the salespeople are good with that? Well, yeah, I'm sure. And well, do you want to talk to them? Well, 5 days later, well, my portfolio managers got mad at me and they said they want to do this and they do it all the time. And so the disconnect between the answer from the compliance officer and the answer from the rest of the people in the firm is something that.
Yeah, no, and I think that's a great point. I think there's compliance speak, legal speak, and business speak, and they don't always, mesh in the same language. So I think that's a very good point. Jenny, how about you?
Yeah, I mean, my conversations are very similar. You just, kind of start the conversation, here's what the new interpretation is, and people essentially say, okay, fine, like we can't avoid being a fiduciary, especially in rollovers, tell us what we have to do, and then you sort of walk through the conditions of the exemption. You have to acknowledge that you're a fiduciary, you have to, really mitigate any kind of incentives that your financial professionals would have. You have to write down the reasons why somebody has recommended a rollover. You have to have this retrospective review. You have to do all these things, and if you mess up, there is a self-correction policy, but you have to self-report to the Labor Department, and if you mess up enough times, they can pull the exemption from you. And, people's sort of eyes glaze over and they say, you know what, no, we don't want to do that. Let's go back and think about whether we can, whether we can do something else. And then it's sort of this iterative process of figuring out, and I suspect, that's what you all went through. And I think it'll be really interesting, especially with the larger record keepers who do get a lot of the rollover dollars, what happens, right? Do rollovers continue? Do people really, what you hear from record keepers is when people leave their employment, they think, I don't want to leave my money with that company. I want my money and I want to take it away. And that's the reason for a lot of rollovers, and we'll see, right? Were they driven just because people want to leave, or were they driven by, behavior out there in the marketplace? Is it better if the record keeper doesn't solicit rollovers? Does that mean, other people will? Like, where are we going to see the money go? Money leaves the defined contribution plan system at a very, very high rate. And if not for investment gains over the last few years, the DC plan overall size would have shrunk. So it'll be really interesting to see where the money goes.
Yeah, absolutely. So we have about 5 minutes left. Yeah, I'd love to hear, it's been a month in. What are some challenges people are seeing? I promise if I get good questions, you'll get the CE code word, you know. So yeah, go ahead.
A quick question regarding the ability to use the exemption for discretionary advice.
Yep.
So does the same kind of look back apply for, giving, regular way advice, apply to the discretionary issue? So if your recommendation due to the rollover is not discretionary, it's just a recommendation, but then your business is providing discretionary investment advice, are you to be looked at as for having discretion over the rollovers?
I don't think so. I mean, unless you have a power of attorney, I don't know how you're going to have discretion over somebody's rollover. So I think that's the problem, right? For lots of asset managers, once somebody rolls over, then you're fine, right? You know how to manage money and you know how to manage conflicts, and it's not a problem. My analogy is, it's like a pool, right? Once they get in the pool, you know how to teach them how to swim, but they're standing on the side of the pool, and you are either giving them advice to jump in the pool with you, or you're just letting them decide whether
Pushing
they're going
them.
to jump in.
You're just pushing them in.
That would be discretion,
That's how
I guess.
kids learn to swim, right? Yeah, but I think that's absolutely right. And I think even in the adopting release, they kind of talk about you can be a discretionary advisor to the plan, a 338 advisor, be a discretionary advisor, in the IRA, but for that rollover, you're not discretionary. It's always going to be a non-discretionary decision, so.
So the exemption would be available.
Yeah, so that's why we want to talk about the discretionary exclusion, because it is kind of misleading. Because you can literally be discretionary, but if you don't have discretion over that specific recommendation, you can use the exemption. All right, 3 minutes. Who wants the code word? Yeah.
What about enforcement down the line of this? Is it still going to be DOL doing cause-based investigations? Is that the plan?
So one of the things you have to do, this retrospective review, you have to do it annually. It has to be completed within 6 months of the end of the year, and then you have to make it available to the Department of Labor within 10 days upon request. So my guess is that the department is going to go trolling around and asking for, people's reports, and then it's going to look through those and decide where to base enforcement actions.
So you anticipate more? My experience has been the DOL comes on the scene for an advisor practice after they've been alerted by an enforcement action on the SEC side.
Yeah.
Or some other client complaint issue and all that. But you anticipate them being more proactive?
Yeah, the DOL sort of statistics are that about 25% of its investigations are that sort of thing, and the rest, they read the newspaper, they do sort of focused enforcement areas and that sort of thing. But here, they're just going to gather data like crazy, and what they're probably going to find out is that usage of the exemption is a lot lower than they anticipate because it's such a pain in the neck.
Anybody else? Still got 2 minutes.
Can't see that.
Oh, yeah, sorry. Yeah, blinding light. Yeah, go ahead.
Sorry, you're on the light. So my personal opinion is that DOL overstepped in their interpretation of the 5-part test. They've been sued. They've got 2 lawsuits lodged against them already. I guess point number 1 is I would say for this group of RIAs, it's a lot easier than people think to do a no advice interaction with a client on a rollover. And I would highly encourage people to do that and avoid this exemption in your practices. The second point I would make is, what's your take on those lawsuits and the potential for success, failure?
Sure. So the one suit was filed in Texas and would likely follow the same path up to the Fifth Circuit as the chamber suit that ultimately turned over the 2016 rule. And that same circuit has been responsible for other opinions, including overturning a DOL advisory opinion. And so I think it is clear that that is a an area there in Texas where there's a very sort of narrow view of the APA. I think the problem with the FACC suit, the one that was filed in Texas, is it was filed as to as preamble language. And I think, the fear or concern is that they're really not going to have standing. What they're saying is we're changing our behavior because we're scared of what the department said in the preamble to a regulation. They're probably their stronger argument, and therefore we have standing to complain about what they're gonna do, even though they haven't really done anything yet. I think maybe the stronger argument is, hey, Fifth Circuit, you told the DOL they couldn't do this, and they sort of did this end run. And that's what the Florida suit says as well. They complain about some FAQs and say, they're doing through sub-regulatory guidance what the courts told them they didn't have the authority to do through notice and comment. Now, I think the department is intending to issue some regulations, and they are intending to issue some changes perhaps to 2020-02 and some other exemptions. So, I would say that these suits are a little bit premature, but, we'll see.
Yeah, absolutely, and definitely, it's always hard to define what courts are going to do. So waiting on, a court opinion that could take months or years is, definitely, make that risk-based assessment. But I hope you'll all join me in thanking these wonderful panelists for bringing us today. Oh, yes, density. The first one, element. Element and density.
It should have been elephant.
Well,
There's an
that's what I
elephant in the room.
thought you said the first time, but
Well, thank you again. You've been a wonderful audience. And again, if you have any questions, again, we do have a DOL committee. I am the person in charge of DOL issues, so definitely feel free to reach out.